You're on live? Good to go, sir.
Good evening to all of you.
So go ahead, sir. Yeah. Can go ahead. It's not necessary.
Yesterday, I was just discussing about summary suits. I would like to repeat it again for the benefit of those who are not present yesterday. Summary suits was previously applicable only to the presidency towns, that is Madras, Bombay, and Kolkata. But in 1976, the CPC was amended. It was made applicable even to provincial towns. And that is how today it is applicable throughout the country, be it a presidency town or not, even provincial towns, a summary suit is maintainable. The procedure for summary suit, again I repeat, is summary suits can be filed only in respect of two contingencies. One is when it is a non-contentious nature, it does not require an elaborate trial. That means, suppose for example, the landlord and tenant relationship is admitted and there is arrears of rent. Instead of filing a regular suit, you can file a summary suit. There is no bar at all. Second one is once it is based on a negotiable instrument like promissory note, bill of exchange, and check, then in that case, a suit can be filed in a summary form under Order 37. The procedure is once you file a plaint into the court, summons are issued to the opposite side, and the opposite side either appears by himself or through an advocate or through a agent duly authorized, and as and when he enters appearance he has to intimate the other side, sir, I've already filed my wakalat in this case, please serve all the papers on me because I'm representing the defendant in the suit. Then, once the said memo is filed into the court, it is a duty of the advocate who appears for the plaintiff to serve on the other side within 10 days what is called summons for judgment. Summons for judgment. It is in the civil rules of practice, it is form number 4A. Then once the summons for judgment is served on the opposite side, within 10 days, the defendant is supposed to file what is called the leave to defend. And the leave to defend, he'll have to spell out his defense and say, sir, what is his defense in the suit? Whether he has got a prima facie case, balance of convenience and hardship, and then he files his documents also. Then, once he files the leave to defend, the plaintiff has got a right of filing a reply or what is called counter to the said application. And once the counter is filed, then both the parties are heard. And if the court comes to the conclusion that the defendant has got a valuable defense, what considering it, then it grants what is called leave to defend. Once leave to defend is granted, the defendant has got a right to participate in the proceedings. He can file his written statement, then issue so on and so forth. It becomes a regular suit. Then, suppose the leave to defend is granted, it is open to the plaintiff to go to the appellate court and take the necessary steps to challenge that leave. It is the other way around also. Suppose leave is not granted, the defendant also go to the superior court and challenge the findings of the court which has not granted leave. Then what happens is, suppose the written statement is filed, the regular procedure takes place. But one advantage of filing a summary suit is it has to be disposed of within a period of 6 months. Elaborate trial is not required. A trial is conducted in a summary manner and disposed of accordingly. And please remember one thing, that as far as the summary suit is concerned, the defendant has no vested right to defend it as a matter of right unless he takes the permission of the court or a leave from the court to defend the proceedings. He has no right to defend it by himself. But one important thing you must remember is, suppose you are appearing for the plaintiff, and when you file a suit of a summary nature, you will have to keep a watch over that suit because no date will be given in a summary suit. What all you have to find out is whether the summons have been served on the opposite side or not. Then afterwards take the necessary steps. But one important thing you must remember is, suppose let us say the other side does not appear or does not file is leave to defend, then what are the consequences? The trial need not take place on merits, the case can be disposed of. So that is the nature of a summary suit as laid down in Order 37. Even chit fund companies also can file summary suits. Why? Because the chit agreement is registered, you are the price bidder, and you have participated in the auction, and then the chit is knocked down in your favor. Then, in that particular case, no defense can be taken, but unless in exceptional circumstances when fraud is played or fraud is pleaded, then only in those cases the courts can go into it. But please remember, a summary suit has to be disposed of within a period of 6 months. This is what we have done yesterday. And most of you were entertaining a doubt regarding mortgage suits. And for the benefit of those who were not present in the earlier lectures, I will again repeat Order 34. Order 34 is called a special suit called a mortgage suit. In all matter, most of you are advocates. You know what is the provision under which you file a plaint. The plaint is filed under Section 26, read with Order 7, Rule 1 and 2 CPC, isn't it? But as far as a mortgage suit is concerned, please bear one thing in mind, that a mortgage suit cannot be filed under Order 7, Rule 1 and 2 and Section 26, but it has to be filed as per the procedure laid down in Order 34. What is the type of suit you can visualize as far as a creditor is concerned or a mortgagee is concerned? Can you tell me, sir? What are the remedies of a mortgagee? Remedies of a mortgagee is he can ask for payment of money, number one. Number two, he can say in default of payment for a decree for foreclosure and for sale of the property. I'll define what you mean by foreclosure. Foreclosure. For means in the beginning itself. Closure is close the rights. What are the rights you want to close? The rights of the mortgagor to redeem the property or get back the property or get it cleared of the mortgage. Here, that is called foreclosure. Here, as far as foreclosure and sale is concerned, the mortgagee gets two rights. One is he can proceed personally against the mortgagor as the debtor, and in default, he can proceed against the property over which he has got a charge. But I also told you that there cannot be an installment decree as far as a mortgage suit is concerned. Order 19 and Order 20 does not apply as far as mortgage suits are concerned. What is normally granted is equity of redemption. What do you mean by equity of redemption? Equity of redemption is within the time frame granted by the court, the plaintiff has to deposit the principal, interest, and the cost of the suit into the court. If it does not deposit it within the time granted by the court, then the second limb comes. That is, the mortgagee can proceed against the what is called against the property that has been offered as security, either by foreclosure or extinguishing or the rights of the mortgagor to get back the property at all times. But please remember, I also told you that the court is not interested in snatching away the property or the debtor or the mortgagor. Court is interested to see that the money which is due and payable by the mortgagor is paid. That is why even if the time limit for redeeming a mortgage has expired, that is 30 years has expired, even then you can always exercise your right of mortgage by exercising your right of equity of redemption. Equity of redemption means once you pay the principal amount, interest, and cost either by payment to the decree holder or depositing the same into the court, the court clears the mortgage and directs the mortgagee to hand over all the documents taken as security, and thereby the property gets freed from the mortgage. But one thing you please remember, Suppose the court grants you 3 months' time to pay back the amount. Suppose, let us say, you are not able to arrange the money, then you can file an application before the court. Sir, I'm trying for money, I'm not able to get it. Please give me some more time. Then the court can extend the time for exercising the equity of redemption from time to time, but not in an unreasonable manner. Of course, to be frank, we as advocates don't allow a matter to end with the lower court. We go in appeal, we go to the High Court, we go to the Supreme Court also. But the question is, in a mortgage suit, two decrees are passed. One is called a preliminary decree, which determines the money which is to be paid and directs the defendant to pay that money, and also passes an order saying that in default of payment, the mortgagee is entitled to proceed against the property that is being offered as security, and also gives time to the mortgagor to exercise the equity of redemption, that is pay back the principal, interest and cost of the suit. This I've already repeated. I'm again repeating it, please. Here, so what are the remedies open to the mortgagee? The remedies open to the mortgagee is he can proceed personally against the mortgagor for recovery of money. That's the first limb. Second limb is he can say, sir, please extinguish all the rights of the mortgagor to get back the property. That is, a decree can be passed for foreclosure. Foreclosure. Please remember, it's two words. Foreclosure. That is closed. That is even before the mortgagor redeems the property. Please extinguish all his rights of getting back the property. But this is subject to a rider that equity of redemption is granted, whereby the mortgagor can deposit that money within that time frame and get the property released from the mortgage. Then what are the rights of a what are the rights of a mortgagee? I have already told you. But please remember, the mortgagee cannot enforce the charge over the immovable property either by foreclosure or charge without waiting for the period that is granted by the court for payment. And please remember, if the matter goes up in appeal, what is challenged in the appeal is the preliminary decree that has been passed by the lower court, and again you have got a right of second appeal. Then you have got SLP also. You can go to the Supreme Court. But ultimately, experience has shown that most of the money suits or mortgage suits ends in favor of the creditor. Normally, in very, very rare circumstances, the mortgagor succeeds unless he stands on formalities and technicalities of law and takes advantage of it and interprets it in such a manner which is to his benefit. Please remember, this is the third time where I'm repeating Order 34. I am making myself clear to you, please. I am going as slow as possible. I need not be cautioned that I'm going fast. Then again we come to Order 33. Order 33 speaks about a pauper suit, P-A-U-P-E-R, pauper suits. That means a suit filed in forma pauperis, I-N space, forma, F-O-R-M-A space, P-A-U-P-E-R-I-S, in forma pauperis. It is normally called suit filed by an indigent person who is not able to foot the expenses for payment of court fee. It is normally filed by a person who has no means at all, no money. Number two, he has means, but no sufficient means to meet the expenditure for payment of the court fee. But please remember, when you are filing a pauper suit, you don't become a pauper. You collect your fees first, though not in full, at least in part. Because tomorrow what will happen is your client will convert you into a pauper. Please remember, all of us practice law not for the sake of social service. We practice law because we want to make money and also to feed ourselves and the persons who are depending on you as far as your family is concerned. We have also got our own financial commitments, but do have sympathy for a pauper. But you don't become a pauper by not collecting the fees. At least the minimum fees you collect. And the rest of the fees, it's your luck. If he has gets money, he'll pay you the money. Then the question is how a pauper suit is filed. Normally, when a pauper suit is filed, it is filed as an OP. OP means original petition. And you will have to clearly mention suit filed under Order 33 in forma pauperis. In forma pauperis means as a pauper. What are the conditions which apply? One is you have no means at all. Number two, you have got means, but not sufficient means to pay the court fee. Am I making myself clear to you, please? This is the third repetition of this order which I am making for the benefit of people who have not attended the earlier lectures. So, a pauper suit means a suit filed by a person who is an indigent person who does not have means, but he has got means but not sufficient means to meet the expenditure for the court fees. Second one is he has no means at all, that he has no mobile or immobile property or earning, but he cannot pay the court fee. Then in that case, the proceeding is filed as an OP, an OP, that is original petition. And normally, whenever a pauper suit is filed, it is necessary that notice should be issued to the government pleader attached to that particular court. Can you tell me who gets the court fee, sir? Even if the court fee is to be paid, who gets that revenue? It is the government which gets the revenue. So the government is interested to collect the revenue. They will not allow a court fee expenditure to go scot-free. That is the reason not only the defendant, but also the government also has got a right of opposing your pauperism petition. And normally, the defendant, who is a contesting defendant, tries to make his own inquiry to find out whether the person who has filed the suit has got means and suppressed and concealed those facts from the notice of the court. Or let us say the pauperism suit, the cause of action part of it has not been clearly mentioned. Cause of action has not been disclosed properly. Or the plaintiff has no triable case, it is barred by limitation. Or, I am putting it or, and all. The court which is trying the matter has no jurisdiction to try the matter. On all these four circumstances, the defendant number one, who is the contesting defendant, can question the pauperism inquiry. And once the counters are filed by the contesting defendant as well as the government, a regular inquiry takes place regarding pauperism. The pauper plaintiff who has filed the suit has to get into the witness box and say, sir, I do not have any means at all. I have means, but no sufficient means to make the expenditure for payment of court fee. Please permit me to file the suit as a pauper. Then he is not effectively cross-examined and it comes out from his evidence really he is a pauper. He does not have mobile property. He does not have immobile property. He has no independent means of livelihood, or he has no source on which he can raise money, so on and so forth. Then in that particular case, court allows the plaintiff to sue as a pauper. What do you mean by suing as a pauper? That means without payment of court fee at the initial stage or at the threshold. But please remember one thing, that it is not a license for you not to pay the court fee. Once you succeed in the suit, prove your case, establish your case, and the court comes to the conclusion that you are also entitled for the cost of the suit. Then in that case, as far as the court fee is concerned, the government will have the first charge over the amount which is due and payable towards the court fee, and that recovers that money from out of the cost that is receivable by the plaintiff. Either the plaintiff can pay by himself, or the money which is granted towards cost of the court fee, it will be recovered as arrears of land revenue from the defendant. Are you able to understand, please? So once the pauperism is allowed, the OP is converted into a OS, a regular suit. And please remember, suppose leave is granted to sue as a pauper, this is appealable. The defendant number one can always file an appeal questioning the orders of the court permitting the plaintiff to sue as a pauper. I'll put it the other way around also. Suppose the court does not grant leave to pay to sue as a pauper, then what should be done? The plaintiff will be directed to pay the court fee which is liable to be paid in respect of the claim. Suppose the plaintiff is aggrieved that he has not been given leave to sue as a pauper, then he can file an appeal before the superior court and challenge the findings as far as the pauperism inquiry is concerned. Am I making myself clear to you, please? Because this is the third repetition which I'm making. Suppose, let us say, subsequent to the pauperism being allowed, the plaintiff purchases some property or he has got a saleable interest as far as the property is concerned, then he will be dispaupered. What do you mean by dispaupered? He will no longer get the benefit of suing the of continuing the suit without payment of court fee. Then, other way around, if the defendant succeeds in proving that the plaintiff has suppressed and concealed certain facts, then he produces documents to show that plaintiff has got property which he has not disclosed. Then, in that particular case, the court will not allow the pauperism. Or even if it allows the pauperism, even at a later stage, the plaintiff can be dispaupered if he is able, if the contesting defendant is able to show that the plaintiff can raise money, he has got property which he has acquired subsequent to the pauper inquiry. Then one more question arises, sir. He has got children. Children have got properties. Children have got lot of properties. They can pay the court fee. But please remember, in these days, which son will pay the court fee of his father? So in that case, what has to be considered is the means of the plaintiff, not the means of his children. Please bear that in mind. So means of the plaintiff has to be determined. What are those two circumstances? One is when he has no means at all. Second one is when he does not have tangible, movable or immobile property. Three, he has got means but no sufficient means to pay the court fee expenditure. Again, to repeat, once a suit is decreed, let us say with cost, plaintiff is entitled for cost. Then in that particular case, the government will have a right or a charge over the money which is to be paid towards the court fee, and the court fee which the plaintiff is entitled to get, that will be taken away by the government and then recover it from the defendant by way of a charge or by way of what is called revenue recovery procedures. That was what we discussed when we discussed Order 33. Then I repeat Order 32. Order 32 deals with suits by minors, persons of unsound mind, and what is called and a result of bankruptcy also. Here, as far as a minor is concerned, minor is incapable of entering into a contract, minor is duly incapacitated, and Contracts Act says a contract with a minor is void ab initio. In the same way, a minor cannot independently file a suit in his own name unless and until he is represented by his guardian. Who is a guardian, sir? Either his father or mother who has got the custody of the minor. Then, as far if the minor, let us say, does not have parents or he does not have near relatives, then in that particular case, it is a next friend. That is his uncle's son, uncle or aunt or whomsoever it may be. They can act as next friend of the minor and they can bring the suit. Then suppose, let us say, he does not have any relatives also. Then in that particular case, the court by itself appoints an advocate to act as a court guardian to take into account the interests of the minor. So it is very, very clear that a suit cannot be filed by the minor directly. He has to be represented by a guardian. And second thing is, if he does not have a guardian, he doesn't have his parents, it should be the near relatives. As next of kin, they can file the suit. Or let us say he does not have anyone also. Then his paternal grandfather or paternal grandmother can act as guardian and file the suit. And the same thing applies as far as a suit filed against a minor is concerned. Then what about persons of unsound mind? You know what do you mean by unsound mind? Pichod. There are a person who is called what is called divana in Hindi. So as far as a person of unsound mind is concerned, he is supposed to not know the consequences of what he is doing or what he should not do. Then in that particular case, a person of unsound mind cannot independently bring an action, or action cannot be brought against him unless and until he is represented by his next friend who is nearest relative. As far as the preference is concerned, the next friend should be the paternal grandfather or the paternal grandmother, because we belong to a patriarchal society where the males have got preference over females. If he does not have grandparents, let us say, that is from the father's side, then from the mother's side, the grandparents who are there, they can also act as guardian. But suppose a person does not have anyone, then in that case, court appoints a court guardian. An advocate is appointed as a court guardian to take care of the case and prosecute or defend the case for and on behalf of a person concerned who is incompetent to bring a suit by himself. Then we go to the next one, idiot. What do you mean by an idiot? Idiot means, in Telugu they call it as eddodu. He is not able to discriminate between yes or no, or is not able to discriminate between what good and bad, or is not able to have worldly knowledge. He does not know anything. Then, in that particular case, an idiot cannot bring a suit by himself, or suit cannot be filed against him directly, but he has to be represented by a next friend. Next friend is normally his nearest relative. Then, as far as persons incompetent to enter into a contract, like what is called, suppose you have been declared as an insolvent by an insolvency court. What do you mean by insolvent, sir? Insolvent is a person, diwala they say. That is a person, as far as law is concerned, is legally dead. But all his assets and liabilities will be administered by an officer of the court called official receiver. The official receiver, on behalf of the person who is disqualified, can bring an action for and on behalf of the person disqualified and take interest in the matter and represent the insolvent in all matters. So these are the various contingencies under which suits by or against minors, idiots, and insane persons, or otherwise disqualified persons, how they are brought. That is what Order 32 speaks about. Then Order 31 is suits against trustees or agents. But please remember, this you can definitely avoid, is not of much consequence. But again, Order 28, 29, and 30, if you have gone through, it is suits by firms, suits by corporations, and suits against government. Let us come one by one. Whenever you want to file a suit against a government under the provisions of CPC, you cannot file it directly against the government unless and until you get the government represented by its principal officer. That is, as far as I think nowadays in the corporate language, the language, I can just put it principal secretary or the chief secretary or the officer concerned, so on and so forth. But when you file a suit when you bring a suit against a public office or against government servants, you will have to get them properly represented. Or if the public authority files a suit, it should be properly represented. I'll take an example, sir. Local bodies, GHMC or the Greater Hyderabad Municipal Corporation is a statutory body created by those days, that is Hyderabad Municipal Corporations Act. And every corporation has to be represented by the chairman or by the mayor, whomsoever it may be. Unless and until they are properly represented, the question of suit is not maintainable. And if a suit is to be brought against the corporation is the government is filing it, then if it's a state government, you'll have to say the state of Telangana, represented by its principal secretary, Revenue Department, Government of Telangana, Secretariat, Hyderabad. That's how the suit has to be brought. And if the suit has to be brought against the government, then you'll have to mention the same description. And especially if it's a local body, you say who is the CEO who is representing that particular public sector unit or the unit which is owned by the state. If it is going to be against the central government has to be properly described. You say Union of India owning South Central Railway, represented by its chief general manager, so and so, or divisional railway manager, or deputy general manager, so on and so forth. Proper description has to be given, and if the suit is filed by the central government, it has to be brought in the name of Union of India, represented by whichever authority, whichever person represents it. Then, if it's a public sector unit which is owned by the state government, then in that case you say the Bharat Heavy Electricals Limited, owned by let us say state corporation, AP State Finance Corporation, represented by so and so. You have to properly get it represented. Whether it's for or against, the question is it has to be properly represented. Then one more embargo, one more restriction you have to know is whenever a suit is filed against the government, be it the state government or the central government, you cannot file the suit without giving the statutory notice under the provisions of Section 80 Civil Procedure Code. What are the consequences of Section 80? When I'm coming to sections, I'll elaborately describe it, please. Then next one is what I was dealing with was suits by or against corporations. You know, if you have got the knowledge of company law, a company is a distinct entity. It has got a perpetual succession and it has got a common seal. Company is different, individual is different. A shareholder cannot say, I am the company and company is myself. No. But a company has got an independent existence and it does not depend upon the life or lives of shareholders for its existence unless and until it is wound up by an order of the court. So, whenever a company has to file a case, it has to be properly represented either by the company secretaries under the articles or by the chairman. And whenever suits are filed against the corporations, it also has to be properly represented. And please remember, the authority of the person who is representing the company has to be clearly mentioned. Where does he get the authority, sir? The articles of association which are there, which empowers him to represent the company in all respects. That is the provision under which the company secretary, under which the chairman or the company secretary derives its powers. Or delegation is given to the company secretary to represent the company, then you will have to say under what regulation he has been authorized to represent. So whenever a corporation brings a suit, please remember it should not be in the individual name, but should be in the corporate name of the company or the corporation represented by its CEO. And the persons who are manning the company are not personally liable. But under the new Companies Act of 2013, even the directors are made personally liable. I think most of you must be aware if you are on the corporate sector. But whenever a company files a suit or a suit is filed against the company should be properly represented. And in other words, I put it, so all actions for and against the company should be brought in the corporate name of the company and not in the individual names. That is what Order 29 speaks about. Order 28 is suits by or against firms. If you have read the Partnership Act, a firm does not have an independent existence sans the partners. How is a partnership defined, sir? A combination, an agglomerate of two or more persons who come together, build the foundation called the infrastructure called a firm, on which the superstructure they proportionally contribute, build up the foundation or what is called bunyad or punadiralu, and based on the investment, the edifice of the company firm comes up. That is what is called the roof level or lintel level. That is called the firm. And the ultimate object is to run the firm and then churn out profits and distribute it among its partners at the end of the accounting year. So first one is pooling up the resources, then building up the edifice called the firm, and ultimate object is to share the profits of the business. But if you see the Partnership Act, a partnership is not properly defined. It is said a partnership a firm has been defined as more than two persons who come together in order to share the profits of a business. That is the firm. But please remember, two or more persons come together, pool up the resources with an intention of starting a business, and based on the investment, the edifice or the superstructure of the roof comes up. That is called the business. And ultimate object is to churn out profits and to distribute it among the partners. It is called a partnership. Collectively, they are called a firm, and individually, they are called partners. And one more thing you must remember as far as a partnership is concerned, a partnership firm has no independent existence. It depends upon the life or lives of its partners for its existence. If the substratum goes down less than two, then the firm automatically comes to an end. And normally, death of a partner ipso facto puts an end to the firm unless otherwise provided. So, whenever a suit is filed by or against a firm, it should be properly filed, and you should say the firm of so and so, represented by its managing partner, so and so, with this address. Then the other partners also, the CPC says, make all of them also parties. Then you know who can file a suit. Under the Partnership Act, it is said under Section 57, a firm has to be compulsorily registered. A registered firm alone can bring an action, not an unregistered firm. But Section 69 goes still further by saying not only the firm has to be registered, but the person who is initiating the suit or suing has to be mentioned as a partner in the extract of partnership under Section 69. So, Section 69 says the firm should not only be registered, but also the person who brings the action should be mentioned as a partner in the register of firms. Unlike a corporation, company has no death, but a firm automatically dies unless otherwise provided. A firm has no independent existence, but a company has got independent existence. But a firm has no independent existence, stands or without its partners. And please remember, a firm is not a corporate entity. Firm is only an agglomerate or combination of two or more persons who run the business. Death of a partner also ipso facto puts an end to the partnership firm. Or the liability of a partner is joint and several, and all of them are liable as far as the debts of the firm is concerned. All these consequences are there. So it suffices for us to know that when a suit is filed by the firm or against a firm has to be properly represented. I am making myself clear to you, please. You cannot say firm of A and company. Nowadays, it's become a fashion to use the word company. It's not a company, but the firm of so and so should get it properly represented. One of the persons should represent the firm as its managing partner or working partner or whatever it may be.
Okay.
So these are all things which I've discussed it earlier, and for the benefit of those who have not attended, again I'm repeating it, I've repeated it. Then we discussed Order 35 also, what is called interpleader suits. Interpleader suits mean where you do not have interest in the subject matter, but there are two rival claimants who are claiming rents from the property or profits from the property. They have issued notices, please both don't pay the rent to so and so, pay the rents to me. Other person also gives a notice, please don't pay the rents to so and so, you pay the rents to me. Then you're in a dilemma as to whom the rents have to be paid. Then in that case, you can find an interpleader suit under Order 35 stating that, sir, I'm not interested in the subject matter of this. Sir, madam, please. You are not interested in the subject matter of the suit, but there are rival claimants as far as the debt is concerned. Please allow me to deposit the money into the court. Whomsoever is the successful party, let him or her or they take the money. But as far as my cost of the litigation is concerned, please direct them to pay my cost. That's the only thing. Only advantage you get in Order 35 is you are absolved of your liability to pay the rent. No doubt you deposit the rents into the court, and the court decides as to who is entitled. Then one more contingency may also arise under interpleader suits. Suppose at the initial stage, both the purchaser as well as the seller come to you. The seller hands over the documents to you as an advocate, having full confidence in you, saying, "Sir, don't hand over the documents to the other side till you hear from me." Then the other side comes to you and say, "Sir, please give the documents to me, sir." Then you are in a dilemma how to handle the matter. Both of them are demanding the documents, and the documents are deposited with you in a trust and confidence. Then in that particular case, you can file a suit under Article 35. Sir, I am an advocate, sir. Both the parties came to me and the documents were deposited with me, and both the parties are claiming custody of those documents. I am in a dilemma what to do. Then I can take the documents, deposit the documents into the court, and say, "Sir, whomsoever is entitled for the document, let them come and prove their case, establish their case, and take the documents." That's how we absolve yourself from your liability to hand it over to one of the parties. There also, an interpleader suit can be filed. That is under Article 35. But a corresponding provision is there in the Rent Control Act where Section 9 Clause 3 says, whenever there is a bona fide doubt or dispute regarding the ownership of the property, the tenant can approach the court and say, "Sir, I have got a doubt in my mind. I do not know who my landlord is. Please allow me to deposit the rents into the court, and whomsoever is entitled, let him take that money." So in the same way, Order 35 is there, which says you don't have any interest in the subject matter. But when there are rival claimants, you can ask the court to permit you to deposit the rents or profits and or the documents into the court and say whoever is entitled for it, let them take it. But of course, the cost which you have incurred as far as the litigation is concerned, you are entitled to ask the other side to provide security for your cost. That is Order 35. Of course, Order 36 you can delete, please. It does not come into real practice or operation. There is suits of special nature in special circumstances. Of course, now we go to, I think these are all which we have done in the past 2-3 classes. We now go to Order, I think I've discussed Order 37 summary suits also. Now we go to Order 38. Order 38 is a chapter which discusses about attachment before judgment and arrest before judgment. Again, I repeat, Order 38 deals with attachment before judgment and arrest before judgment. See, when can you get back your debt, sir? Suppose a decree is passed. When can you get it? You can get the amount what is decreed or what is claimed by you only after the judgment, isn't it, sir? Normally. But in such circumstances, suppose the defendant has got means to pay the debt, but he is trying to secrete or sell away or alienate his assets, mobile and immobile, in order to screen away the property from attachment in case the plaintiff succeeds in the suit. Or he is trying to run away from the jurisdiction of the court, or he is trying to delay and defeat your claims. And even if you get a decree, ultimately the question is you may not have any property over which you can proceed and then recover your debt. In those circumstances, you can ask for Order 38, Rule 4 and 5 for attach the property of the defendant even before a judgment is passed. Again, I repeat, suppose the defendant, in order to delay and defeat the claims of the plaintiff, is trying to alienate or encumber or charge the property which is owned and possessed by him in order to frustrate the attempts of the plaintiff to recover his amount from out of that property. Or is trying to run away from the jurisdiction of the court or is trying to abscond in order to avoid the ultimate decree which is going to be passed, in those circumstances, the property which is owned and possessed by the defendant can be attached before judgment. Shall I repeat it again, please? When the defendant has means to pay, when the defendant is in a position to pay the debt, he is deliberately avoiding and evading payment of the debt, or is trying to sell away his property or encumber or charge his property or transfer his property in order to defeat the lawful claims of the plaintiff. And even if the plaintiff is able to succeed in the suit, he may not have any property over which he can proceed and then recover his money. Then, in those circumstances, the property owned and possessed by the defendant can be attached before judgment. Am I making myself clear to you, please? But before the 1976 amendment, the property can directly be attached. But in 1976, it was found that this provision was being misused by many parties. Here, suppose I have to get only about 10,000 rupees from you. By attach a property which is worth 10 lakhs, is it just and proper, please? Or I call upon you and I request the court to attach that property. It is nothing but harassment. So that is the reason in 1976 this provision was amended, whereby they said an attachment when sought for cannot be ordered directly or immediately, but what the court can do is it can order conditional attachment. Instead of attaching the property, it can order conditional attachment. I please underline the word conditional attachment. What do you mean by that? What the court does is it directs the defendant to furnish security for the suit claim with costs within 2-3 days or 4 days, or provide third party security which can satisfy the claim of the plaintiff. Then within 3-4 days, if security is furnished, then in that case what happens? A regular inquiry takes place. Let us take a situation if the defendant does not furnish security within the date that is given by the court or within the time given by the court. Then in that case, court has no other alternative than ordering that property to be attached. What do you mean by attached? Attached means there is a prohibitory order issued that that particular property is subject to a charge of the court or charge regarding the money which the plaintiff has to recover. Please remember, under the 1976 code, an attachment cannot be ordered directly. Only thing is the court can ask the other side to furnish security. Why you should not furnish security? A show cause should be issued, and within 3-4 days, the defendant will be called upon to furnish security. And on receipt of the application for attachment before judgment, the defendant has got a right of showing cause why his property should not be attached. And only after hearing the defendant, the court can pass attachment. And if security is furnished, let us say, then in that particular case, the other inquiries can go on. So why this provision is made is to see that dishonest defendants, dishonest debtors do not take advantage of law and try to sell away that property or encumber the property or transfer that property in order to defeat the claims of the plaintiff. Then in that case only attachments are ordered. And under the amended code in 1976, that is amended Act 46 of 1976, it is said straightaway attachment cannot be ordered unless opportunity is given to the defendant to furnish security, and on his failure to furnish security and show cause, then alone the property can be attached, not otherwise. Or don't pass an attachment order without hearing the other side, because of the doctrine adi alteram partem. That is, don't condemn a person unheard. Principles of natural justice demands that the opposite side also has got a right of raising his defense being heard, and the matter decided accordingly. Am I making myself clear to you, please? That is what is called attachment before judgment. Suppose you visualize a situation pursuant to the orders of the court, security is furnished or the money is deposited into the court, the attachment petition is closed. Against that order ordering the other side to furnish security, an appeal or revision can be filed in the proper court. If attachment is not granted, then in that case, the plaintiff also can go to the superior court. And please remember, any attachment made directly without hearing the other side or giving the other side an opportunity of furnishing security or explaining his stand is illegal under the law. That is Order 38, Rule 4 and 5. Then we come to arrest before judgment. What do you mean by arrest before judgment? Suppose, let us say, a person is trying to run away. Nowadays, I think most of so many scams are taking place. Whenever a person is involved in a scam, he tries to run away to UK or run away to USA or run away to Uganda, so on and so forth. Then, in that particular case, suppose he wants to abscond from the jurisdiction of the court in order to avoid the lawful claims of the plaintiff on proper reasons being shown, on proper grounds being shown, and opportunity be given to the other side, the defendant can be arrested before judgment. But please remember, it's a rare and rarest of cases where arrest is ordered before judgment. This is what Order 38 speaks about. Shall we go further, please? We go to the next order, which is very, very important, which is feeding most of our advocates today. That is called injunctions. 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 This word injunctions is spelled in a different way by different professionals. As far as a doctor is concerned or a surgeon is concerned, he knows only one word called injection. 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 He does not know what is meant by injunctions. But as far as a legal man is concerned, he knows only one thing called injunctions and not injections. And what do you exactly mean by injunction? Injunction is, it's called a preventive relief, or it's called a prohibitive relief, or it is called a relief which is granted to safeguard the interests of both the parties. The injunction is normally, suppose when you are having fever, you take crocin, you get some relief. Or suppose you are having a headache, you apply amrutanjan or zandu balm so that some relief is obtained. Or suppose you are having fever, you take crocin or a paracetamol or whatever mall, it is now dolo also. In the same way, suppose an injury is caused to a person, before coming to injunctions, I'll give you the history of injunctions, please. Suppose an agreement is made between the plaintiff and the defendant. The defendant agrees to sell a particular property for a particular price. Advance is already paid. Rest of the money has to be paid after compliance of certain basic requirements. And because the value of property every day is escalating, when we make the contract, we agree for 75 lakhs. But the same property, if it's going to be sold, the next day it shoots up to 1 crore. Please remember, will you sell it to me for 75 lakhs or will you sell it for 1 crore? Citing, sir, prices have increased, sir. I'm not prepared to sell it at 75 lakhs. I'm prepared to pay back that 75 lakhs and 5 lakhs extra, but I'm not going to honor the contract. Earlier in the common law, it was said a breach of contract was only supposed to be a civil wrong. The relief of specific performance or enforcing the agreement or preventing a violation of an agreement was not provided under the CPC and under the common laws. But slowly what happened was petitions started pouring into the Queen to decide the matter. And the equity courts came into existence because Queen of England those days, it was almost ruling 2/3 of the world, including India, in the name of East India Company, of course. The question is, equity stepped in, where what happened was the Queen or the King found it difficult to cope up with the petitions which were pouring in to the Queen for redress. Then the equity court stepped in. The Lord Chancellor, who is now called the Prime Minister today, was the person who was delegate. He was the holder of the King's conscience and the King's seal. And then the matters were referred to the Lord Chancellor, and they created courts called equity courts. And equity courts, they said whenever trust and confidence is reposed by a person in another person, and the other person, based on the trust and confidence, betrays that confidence, commits a breach of faith, and then the person to whom that representation is made changes his position, which he would not have done but for that particular trust and confidence, then in that case, court should not be helpless to come to the rescue of a person who has been wronged or has been victimized. So they slowly develop the doctrine of injunction. So injunction is a child born out of equity, where they say once there's a contract, it should not be violated by both the sides on various issues. So injunction is nothing but, suppose an agreement of sale is made, in the meanwhile the property is sought to be transferred, or property sought to be alienated, or property sought to be encumbered. Then, in that case, courts normally come to your rescue by granting an injunction. Look, mister, there's an agreement already. You are prevented, you will be restrained not to sell the property, not to encumber the property, not to charge the property in any manner pending the enforcement of the contract. Then you take the case of a partition suit. You take the case of a partition suit. There are four brothers. One of the brother files a suit for injunction, for suit for partition. Then, in the meanwhile, the other brothers who are in possession of the property are trying to alienate the property in order to see that I don't get anything. Then, in that case, court can prevent the opposite side from selling the property or encumbering the property or charging the property in any manner pending disposal of the suit. Then various circumstances are there where injunction can be granted. Then injunction is of four types. One is interim injunction, another is temporary injunction, another is perpetual injunction, and another is mandatory injunction. We'll go one by one, please. As far as the principles of injunction is concerned, it is dealt with by section 37 to 39 of the Specific Relief Act 1963. First, we'll go one by one. Interim injunction. What do you mean by interim injunction? Normally, most of you are advocates know whenever you file a suit for injunction, you file it with an out of order petition. That is, you want the matter to be heard immediately and disposed of immediately. But please remember, I'm talking about the position scenario before the 1976 amendment. Whenever a suit is filed for injunction, court used to grant ex parte injunction without hearing the other side, without giving an opportunity to the other side to file the counter and also the necessary documents. But 1976 code, the amended provision says no ex parte injunction should be granted without notice to the opposite side. The opposite side has to be heard, and opposite side should be given an opportunity of filing his reply or defense and his own documents. Slowly, what happened was courts were helpless, and unless injunction can be granted only in special cases where for court, for reasons recorded in writing, court can issue injunction. But what the courts have evolved is they have evolved a curious principle of what is called status quo. What do you mean by status quo? In labor law language, it is called laissez-faire. Things stand where they are. Please remember, I remember one of the judges of the High Court who retired as the Chief Justice of Chennai High Court, also late Justice Subhashan Reddy, who said, what is the status quo? Status quo is nothing but a koja order. Neither it's a male nor a female. And status quo gives rise to wild interpretations. According to one, a particular position is a status quo. According to the other person, status quo is something else. Then in the case, once a status quo order is passed, the other side flouts and violates the order, changes the position which would not have done if injunction was granted. Then that's the reason Justice Subhashan Reddy, as he then was, he subsequently became the Chief Justice of Chennai High Court. He said, either you grant an injunction or don't grant an injunction. Simple. But what happens is, checks and balances are also imposed. And you as an advocate, you ask the court to pass an order of injunction. Courts are finding a very easy way of disposing of matters. They order status quo if you pressurize more, or they issue urgent notice to the opposite side. And please remember, they give you 2, 3, or suppose the court grants you injunction or status quo, It will be only for a limited period, 3 days or 4 days, in order to see that the summons are served or notices are served on the opposite side. Then once an injunction is granted, let us say, court passes a speaking order, then in that particular case, you will have to send the copies of the plaint, copies of the petitions, copies of the material papers to the opposite side, and then file an affidavit under Order 39, Rule 3, saying that it is called compliance affidavit. Unless you file the compliance affidavit into the court, along with the postal receipt, injunction orders will not be communicated to the other side. Suppose an injunction is granted or a restraint order or a prohibitive relief is granted for a limited duration of time, it ends on the day till which the interim order is given. This is called interim injunction. Interim injunction is nothing but what is called an injunction order given for a limited duration of time. It is not forever. That is subject to notice being given to the other side and the other side being given an opportunity of filing his or her or their counter and their documents. And then an interim injunction which is granted, let us say today is what? Today is 22nd, let us say. Interim injunction will be granted, let us say till 26th. And the other side appears on 26th. Then what is your duty as an advocate, sir? Your duty as an advocate is to file an extension petition under section 151. Sir, you have already granted interim injunction on so-and-so date, which lapses today. Please extend the interim injunction till such time the other side files a counter. It is your duty as an advocate for the plaintiff to go on filing petitions till the injunction application is heard. If you don't file an extension petition, please bear it in mind. An interim injunction given for a limited duration of time dissolves itself. And next we pass on to what is called the question: suppose injunction is granted and it is violated or breached by the other side, you got a provision called Order 39, Rule 2A, where you can punish the opposite side for disobedience of the order. I think with this we shall stop. I'll go in detail when the next lecture, that is tomorrow. Now with the time for interaction, please. You are free to ask, and please remember, let us not have any crosstalk in between.
Ravi sir, Sister Ravi sir.
Mr. Ravi. Mr. Ravi, please put your question, please. Mr. Ravi.
Mr. Ravi, can you explain status quo again?
Sir, please tell your
Status
name.
quo.
Pardon? Pardon?
Status quo, I want.
Status quo is
Status quo.
status STATUS space QUO. That means things stand where they are. That is, neither you can do anything nor the other side can do anything, is it? Suppose the land is there, you shall not go near the land, and I also should not go near the land. That is, things stand where they are. That's why I said it is based on labor law, laissez-faire. Things stand where they are. They don't move at all on either side. Neither you can do anything nor other side can do anything. That is called status quo, sir. But it is not defined in the civil procedure code anywhere. Yes.
Yeah. Recently we approached one case, sir.
Yes.
So we are asking the perpetual injunction, but court has given the status. So
Please remember, perpetual injunction cannot be asked at the initial stage at all. I'll come to it under what circumstances it can be asked when we go to the third aspect. Only thing is, you can ask for the injunction application to be expedited and heard. I'll come to it in the tomorrow, that is in the next class. Are you able to follow, sir?
Okay.
Next question,
Yes,
sir.
sir.
Next.
Hello, sir.
Yes, Mr. Shruti Kirtan.
Yes, sir.
Yes.
Sir, I have taken a loan from the bank.
Yes.
So I am not having any property.
Right.
So, being as an advocate, an advocate has taken a loan, sir.
Right. Is it you?
No, sir.
Right.
One of one of my friends.
I don't know how they gave the loan also. No one gives loan to an advocate or a policeman.
No. Before entering into the profession, he got a loan.
Right,
Then he
okay.
became as an advocate.
Agreed.
So, then he is not having any property.
Right.
Then he is not a earner and all.
Pardon?
The profession. So he is not earning money through other sources.
And not to the profession also.
Yes.
Right.
He is only advocate.
Right.
So his professionally he can get bread and butter.
Oh.
So then how will be the circumstances? He is unable to repay the loan.
If he is unable to pay the loan, the only option open to him is to file an IP, insolvency petition, and declare himself as an insolvent.
When he became as an insolvent,
He cannot practice also, sir. It's a bar for practice.
Isn't there some other redressal, sir?
Or the other redressal is to steal, beg, or borrow and raise that money.
That's all.
Right, sir.
Thank you.
Yes. Next, please.
Sir, good evening.
Good evening.
I am Swarna from Visakhapatnam.
Yes, madam.
Sir, I was taken on NOC case, a matter of 2016. It was gone through trial and lastly it came to an argument.
Yes.
But while I applied a CA copies for all the documents,
Yes.
I have received the document set and initially the previous advocate has filed a neat copy in that.
Right.
And what is the case is belongs to the declaration of this sale deed as a null and void.
Okay.
So the different party
Yeah.
as a second registration,
Right.
and I am the plaintiff.
Right.
Plaintiff, my party is a first registration party.
Okay.
So while they are filing a neat copy of that, previous advocate did not mention the sale deed.
Right.
The different party has executed two deeds. What
Right.
is first? First one is sale deed, and next one is rectification deed.
Right.
The previous advocate has mentioned only rectification deed number in the prayer of the neat copy.
Yes.
Now at the end of the time, I received the certified copy and observed that yesterday. So now at the end of this case, arguments is going for filing of arguments. It's coming now. I can file the amendment petition.
You can file it and say that the previous advocate has been negligent. He has not mentioned it. Please, party should, for the mistake of the advocate, party should not suffer. Please allow me to amend the plaint. That's the only relief open to you.
Oh, sir.
Anyway, I'll be coming to Vizag one of these days. I'll meet you there.
Sir?
I'll be coming to Vizag one of these days.
Oh, sir. Okay, sir. Nice of you, sir.
So the
when will be?
Only alternative for you is to ask for amendment, please.
Amendment now they'll accept, sir.
You will have to show the special circumstances saying that the advocate has been negligent.
Okay. So under order 6 and rule 17, we have to file, sir.
That's the only provision, madam. But please guard yourself against order 617 bracket 2, where they say after evidence affidavit has been filed and issues are settled, amendment can be allowed only as a special case, not as a matter of right.
Okay, sir.
Right?
Yes, sir. Thank you, sir.
Welcome.
All right. Can we wind up the class? Mr. BSR, you have a question here, I hope so. In the chat box. Mr. BSR. Mr. BSR, I think there's a question from your end. Are you there? Mr. BSR.
Ask him to reserve it for tomorrow.
Surya.
Sir, good evening, sir.
Good evening. Please tell.
Sir, ఒకటి సార్
Please ask me, sir.
సార్ ఒకటి పార్టిషన్ డీడ్ వచ్చేసి 2013 లో ఫైల్ అయింది సార్.
ఓకే.
దానిలో 3 ప్రాపర్టీస్ ఉన్నాయి సార్ షెడ్యూల్ లో.
రైట్.
సార్ షెడ్యూల్ ఒక ప్రాపర్టీ వచ్చేసి ఒక పార్టీ వేరే వాళ్ళకి అమ్మేశారు సార్.
ఓకే.
సో ఇప్పుడు ఈ డిఫెండెంట్స్ లో కొన్న పార్టీని ఇంక్లూడ్ చేశారు కానీ ఈ అమ్మిన వాళ్ళని ఇంక్లూడ్ చేయలేదు సార్.
అమ్మినోడు కూడా పార్టీ చేయాలండి.
అదొకటి సార్. ఇంకోటి ఇది 2014 లో మా క్లయింట్ వచ్చేసి ఇది అది అయిపోయింది సార్, ఎక్స్పర్ట్ అయిపోయింది D1.
సరే.
సో ప్లేంటిఫ్ అటెండ్ కాలేదని చెప్పి 2017 లో డిస్మిస్ చేసేసి సార్ కేసుని.
ఓకే.
డిస్మిస్ చేసిన తర్వాత మళ్ళీ రిస్టోరేషన్ ఫైల్ చేశారు సార్ 2019. ప్లేంటిఫ్ రిస్టోరేషన్ సూట్ ఫైల్ చేస్తే 2019 లో ఫైల్ చేసింది సార్.
ఓకే. ఓకే.
24 ఏప్రిల్ లో రీసెంట్లీ 2 months కింద అది రిస్టోర్ అయిపోయింది సార్ కేసు.
రైట్.
రిస్టోర్ అయిపోయిన తర్వాత తను చీఫ్ ఫైల్ చేశాడు సార్, క్రాస్ ఎగ్జామ్ చీఫ్ ఫైల్.
రైట్.
సో దీంట్లో D1 వచ్చేసి ఎక్స్పర్ట్ అయింది సార్, 2014 లోనే ఎక్స్పర్ట్ అయ్యిండు D1.
చూడండి, ఒకటి రెండు ఉందండి. ఒకటి ఎక్స్ పార్టీ ఆర్డర్, అనదర్ ఇస్ ఎక్స్ పార్టీ డిగ్రీ. Ex parte order, you can file an application to set aside the ex parte order at any time under Order 9, Rule 7 by showing sufficient cause. If it's a decree under Order 9, Rule 13, you have to file, but should be filed within 30 days. Since you say it's only an ex parte order and that the suit is also restored, you get a fresh cause of action. You can always question it by saying, I want to contest. You can file an application under Order 9, Rule 7. There's no limitation for that, please.
ఓకే సార్, ఇది ఎక్స్పర్ట్ చేస్తాము, బట్ ఇప్పుడు ఇక్కడ కండోన్ అడగాలి సార్.
అక్కర్లేదండి. ఆర్డర్ 9 రూల్ 7 కింద you file an application to set aside the ex parte order, and along with that you also show your bona fides by filing the written statement also.
Okay.
Yeah. There's no time limit for filing a restoration of a suit and no time limit for setting aside ex parte orders, please.
కండోన్ కూడా అవసరం లేదా సార్?
అక్కర్లేదండి. ఆర్డర్ 9 రూల్ 7 కి 9 కి కండోనేషన్ అక్కర్లేదు.
ఓకే, దాంతో పాటు WS ఫైల్ చేస్తే అయిపోద్ది.
అది షో యువర్ bona fides. Now one more advantage for you, the suit has been restored. So at least now give me an opportunity of contesting it.
ఓకే సార్. ఇంకోటి వచ్చేసి సార్, ఈ ప్లేంటిఫ్ వచ్చేసి ఒక ప్రాపర్టీని దాంట్లో అడిషన్ చేయలేదు సార్, 4 ప్రాపర్టీస్ ఉంటాయి.
Then you can also ask for addition of that property also, which has been suppressed.
Okay, అంటే WS లోనే అడగాలా సార్?
WS లో అడగాలి. You can file a separate petition also to add this property.
ఓకే, లేదంటే సార్ ఇప్పుడు మన WS ని కౌంటర్ క్లెయిమ్ ఒకటేసారి వేయొచ్చా సార్?
వేయొచ్చు. You have to file it along with the written statement, sir.
Sir?
You will have to file the counter claim along with the written statement, not separately, please.
Okay, కలిపేయమంటారు.
And the plaintiff has got a right of filing additional written statement in case you raise a counter claim. And you have to take the permission of the court to raise a counter claim under Order 8, Rule 6A.
Okay.
Yeah.
So ఇప్పుడు కౌంటర్ క్లెయిమ్ ఉంది, WS ఒకటేసారి ఫైల్
చేసేసి మీరు కౌంటర్ క్లెయిమ్ రేజ్ చేస్తున్నారు కాబట్టి you must also file a permission petition under Order 8, Rule 6A.
Okay, sir.
Right.
Thank you, sir.
Welcome. Any more questions, please?
All right, we are concluding the class as of today. See you tomorrow again. Thank you very much.